Welcome. Jeff Manzelli here with 30,000 Foot Wealth Management. Today, we're talking about the difference between a will and a trust. And we're going to throw in a couple extra things also. So first of all, many of your assets can be directly beneficiary. So your 401k or your IRAs, your bank accounts can have direct beneficiaries on them. So sometimes it makes sense to put those assets directly beneficiary to your kids or to your spouse or someone you want to get them. And it takes care of these, it's basically outside of a will or a trust. Sometimes it makes more sense to do everything through the will, or sometimes it makes sense to do everything through the trust. We're going to talk about those things today. We do recommend everybody have a will or a trust because there's always assets that you may not be able to put a direct beneficiary on, such as cars and different things. So first of all, we're going to talk about a will. And a will is very simple. Sometimes it's half a page, sometimes it's a page and a half, which says that we want all of our assets to go to our kids evenly, 50-50. And it's very simple. There's not too many intricacies inside a will. You can be more elaborate, but a will is basically very cost effective. You can usually get all the documents you need, including powers of attorney and everything outside under $1,000. And what it does is it tells the probate court what you want to do with your assets. So you are not avoiding probate with a will, but it tells the probate court exactly what your wishes were. It's very good for small estates, very economical. There's not too many moving parts, so a lot of times you don't have to change it very much. So it's, especially with new laws, there's very few laws that come up that mean that you have to change your estate or your will. And so it's very simple and easy. Next, we're going to talk about a trust. Now, a trust can be very simple or it can be very complex. And the biggest thing that we see in a trust is that you're able to control the assets after death. So for me, I have younger children. I have a daughter and a son who, if something were to happen to my wife and I, they would be inheriting a large sum of money. And if you have ever seen an 18-year-old with $500,000 or $1 million, Corvettes get bought, parties happen, and it's amazing how they get different friends who just want to come and spend their money. So I've seen it happen many times. You want to protect your kids. So the trust allows you to control your assets after death. So my two children, I have in my trust to say that they are not able to access their money until they are 25, half of it, and then the rest at age 30. Before that, I've put a trustee, my brother, to say that he is able to help them out with health, any health insurance needs, education, maintenance, and support. So for their daily living and those things. But I don't want them getting all their assets until they are, at least 25, working and being model citizens. Because the worst thing you do is give a child who is not good with money or has a drug problem too much money, then they can hurt themselves. The nice thing in my trust, I can control it to say that I give discretion to my brother that if for some reason they are a drug addict, God forbid, or they have an alcohol problem, that he can say, no, you're not getting a lump sum. We're going to stretch it out over the rest of your life. So it's more to protect your kids. You can control your assets after your death. Again, very complex or simple. Sometimes we have clients who have special needs children and they're on state aid. Well, when they inherit assets, it could knock them off of their state aid. So a special needs trust needs to be built for that person to make sure that that trust is taken care of. Sometimes we have, sometimes our kids are married to people we really don't approve of, or they're having a rocky relationship and their marriage isn't very solid. You want to make sure you have a trust that is built correctly, that your daughter or your son will inherit the assets and your son-in-law or daughter-in-law won't, once they inherit a large sum of money, say, oh, now it's time for me to break up because we have a large sum of money that's going to be split. You have the ability to control it now to say only your daughter or only your son are able to receive those assets. Fantastic thing about trust is that it avoids probate. Your assets in the trust do not go through probate. And probate means that your estate is being shown to the public to say, does this estate owe anybody anything? And what we've seen many times is that, oh, I see Jeff has a large estate and I did some work for Jeff 3 years ago in his driveway. He never paid me. He owes me $15,000. So then somebody says, oh, it's a probate court. I'm going to go ahead and say that Jeff owes me $15,000. I'm gone. I'm nowhere to be found. Now they're trying to say, yes, you do owe them or you don't. And the judge has to defend or figure it out. Well, the probate court, the trust avoids probate, which is a very big strength. In this area, we see trusts in around the country being right around $2,500 to $3,500, depending on how complex it is. Biggest thing on a trust is you have to make sure it's funded. So sometimes attorneys and us decide that it's best to have your IRAs go through your trust. Sometimes it's better to have your IRAs directly beneficiary to your kids or your 401k. Most of the time we say, go ahead and put your house inside the trust and your life insurance inside the trust. There's certain tax benefits and breaks that you really want to make sure you understand about where to function or where to put the trust or what to put in the trust. So think of a trust as a document or a box. And unless you put assets into it, it's basically a blank box. So make sure that when you get that list from your attorney after they complete it, that you have to go change the title or change the beneficiary on this account and these accounts. Make sure you do it to make sure you fund the trust. So a couple things, additional items, check your beneficiaries and everything. We talk to our clients every year or every other year to make sure that if somebody passed away or some God forbid thing happened, that you don't have an old beneficiary on, which just complicates everything after you're done or you're no longer here. Again, your house is your biggest asset. So the easiest way to put a beneficiary in your house is a ladybird deed or a transfer on death deed. And this means that you're putting a beneficiary in your house. It's usually the biggest asset you have or one of them. And you want to make sure that the house is going through what you want, not going through probate. Powers of attorney, very, very important to have a power of attorney for health and a power of attorney for financial. And what this means is that, spouses or kids can't call me and talk to me and have me make financial decisions unless they have powers of attorney for these accounts. Now that's while you're still alive. If you're incapacitated, the powers of attorney allow them to act while you're incapacitated, whether it's to make decisions for health or to make decisions on the finances, just to pay bills and things. A lot of times your kids will need a financial power of attorney. And we always recommend talking to an attorney. They may uncover something that you never even thought would be a specific problem. Like I mentioned before, the children who your spouses may not be perfect. And so comparing it, going for a attorney versus online documents, we've seen a couple online documents that worked well for very, very simple estates. But anything that may be out of the ordinary or be a little bit different, we do recommend go see an attorney and get it done correctly. Hopefully this helps and looking forward to talking to you soon.